Hello boys and girls, welcome back. So now let us try to discuss the important sections in this IBC procedure. So now we will be discussing all the provisions with respect to filing of applications. So this video we will be dedicating for section number 7. So we already know sir, section 6 said who are the people who can file an application. So applications can be filed by applications can be filed by these people sir. One is your financial creditor, and when financial creditor is filing an application, he will file an application under section 7. Second, it can be filed by your operational creditor, and when operational creditor is filing an application, he will be filing an application under section 9. He will be filing an application under section 9 provided he fulfill the conditions which are given in section number 8. So can I say he can file an application only if he fulfills all those conditions which are given in section number 8 sir. And corporate debtor itself can file an application under section 10 sir. Okay. So now our discussion in today's video will be with respect to filing of application by financial creditors. Okay, let's see what this is sir. Now sir, as usual sir, now our company, say for example JP Infra. Okay, so imagine sir, on this company and this company is what we are talking about sir. This is our corporate data. So JP Infra is our corporate data sir. Now sir, imagine sir, JP Infra has taken loan from some bank, say for example SBI. So they have taken loan from SBI bank sir. Now sir, they were supposed to pay sir, but they did not. So obviously this is a financial debt. This is a financial debt, and there is a default, and SBI is a financial creditor. SBI is a financial creditor sir. Similarly sir, so this is our financial creditor type number 1 sir. Similarly, home allottees will be also financial creditor, as we have already seen in subclause number F of what you say the definition of financial creditor sir. So there also I have discussed sir, all those home buyers, or you can use a word allottees, है so these people are also coming within the definition of what sir, financial creditor sir. Okay, so maybe these people ka also default is possible. So these people are also financial creditors of the company sir. Or sir, imagine JP Infra has issued debenture sir. So can I say debenture holders can also be the financial creditors sir. Debenture holders can also be financial creditors. Agreed? So can I say all these are nothing but our financial creditors? Now, presently what I will be doing, sir, our discussion will be only with respect to type 1 financial creditors. Yes, type 2 is also there, type 3 is also there, but my focus will be more on what, sir, this financial creditors. Okay, so subsequently I will be talking about small amendment which has come for home buyers and another for debenture holders. A small amendment it is, we will discuss sir. Okay, so now the question is, imagine SBI is one bank sir, another bank is also there. Say for example we have another bank which is ICICI bank sir. Okay, financial institution definition mein banks are also coming sir. So this is bank number A, this is bank number B sir. Sir, JP Infra has done default of both the banks sir. Okay, now my question to you people is, who can file an application? Okay, presently my focus is only on banks sir. We are not talking about second and third wala financial creditors. So if there is a default of SBI, if there is a default of ICICI sir, है ना? So now the question is, who can file an application? Obviously anybody can file an application. So can I say first, financial creditor itself can file an application? Agreed or not sir? Financial creditor itself can file an application. In other words, imagine default has happened for SBI. Can SBI file an application? Answer is yes sir. Or financial creditor can file an application with another financial creditor. This is nothing but our joint application. Sir, can SBI along with ICICI together they can file an application? Yes sir. So lawmaker said this model is also allowed, this model is also allowed. So SBI wala model is also allowed, or SBI along with ICICI bank if they want to file an application for CIRP, sir, this is also allowed, sir. So both ways application can be filed, sir. I hope you understood this point, sir. Okay. Now, sir, next point I want to discuss. Sir, ये जो now what we will also do, sir, here we will also include some other categories also, sir. So imagine ICICI Bank is there, SBI is there, sir, and say for example we also have Mr. X who has given some loan to JP Infra and Mr. Y who has given some loan to JP Infra, sir. Do you think these people will also be called as financial creditors? Answer is yes, if default has happened, sir. Okay, so all these people are financial creditors, sir. Okay, very nice, sir. Why I am saying this, we will discuss. Okay, now my question to you is this, sir. So SBI is filing a application with whom, sir? JP Infra. Why? Because there is a default. Why? There is a default, sir. Okay. Now question is this, sir. Sir, imagine a scenario. Default तो हुआ है, but default is only of SBI, not of ICICI. Just for example, default is only of what, sir? SBI, not of ICICI, sir. Okay, so ICICI has given the loan, but no default has happened. JP Infra is regularly paying those EMIs or that money to whom, sir? ICICI. Default is only of SBI, sir. Okay, so now question ये है, SBI does not want to file an application. Can ICICI file an application? है ना? Now my question to you people is, can ICICI file an application for a default? Now default किसका हुआ है, sir? SBI का. Default किसका नहीं हुआ? Whose default has not happened? ICICI, sir. So now can ICICI file an application for default not owing to him but for default of another financial creditor? Is this possible? Answer is this is also possible. This is also possible. In other words, a financial creditor, he can file an application individually or jointly. That in application he can file for default of his money or for other financial creditor money also. That is also allowed. So you may be wondering, sir, what is this? Sir, default हुआ है SBI का, pain is to SBI. Sir, why ICICI is trying to file an application? The logic is very simple, sir. Today, the default has happened for SBI, sir. Now, maybe chances are bright tomorrow default can be also of ICICI Bank. Default can be of another financial creditors also. Hence, lawmakers said, sir, why should we take up this matter to that extreme level, sir? If the matters can be resolved at earliest stage only, let us try to do that, sir. Similarly, if you have any medical problem, I did say that try to find the cure as early as possible. Similarly, today default has happened for one financial creditor. Yes, he is not interested in making the application, but another financial creditor may make an application thinking what? Proactively, sir, thinking what? In future that a default can happen to him also, sir. Hence, this law is trying to provide remedy for those people also, sir. So, one financial creditor, when he is filing an application, he can file an application for a default of his money also or for a default of other financial creditor also. I hope this logic also you might have understood. Sir, need not write anything, sir. I have designed our material in such a manner that by reading things you will understand very easily. Not at all a problem. And in fact, there is no requirement of any charts. Our material is designed in such a manner that all those charts are also incorporated in that, sir. Okay. Whatever I'm trying to tell, if you can understand, that is more than enough. Yes, running notes, if at all somewhere you want to write, you may write out, sir. So what are the conclusions we have found out, sir? First, who can file an application? Financial creditor, he himself can file an application, itself can file an application, or he can file an application with another joint financial creditor. Next, he can file an application for his own default or for the default of other financial creditors. That is also allowed. Now, second point, may lawmakers have also said the application can be filed by any other person. Application can be filed by any other person. Any other person on behalf of financial creditor. Again, what are the words I'm using, sir? Application can be filed by any other person on behalf of what is a financial creditor who is notified by CG. Okay, so three words I'm using, sir. Application can be filed by other person on behalf of financial creditor, and that other person has to be notified by central government. Now, the question is, did central government notify anybody, sir? Answer is notification has come. Let us see who are those people, sir. So 4 people को central government has notified. So government has notified 4 persons, sir. So first let us try to see what is the answer, sir. So you will be finding first person notified here is guardian. Next person is executor or administrator of estate of financial creditor. Next is trustee, including debenture trustee. On fourth wala is person duly authorized by board of directors of the company. Okay, so what is that we are reading, sir? Who can file an application? Who can file an application under section 7 for initiating CIRP before AA? AA is nothing but your NCLT, sir. But still, I told you better use word adjudicating authority only instead of writing NCLT, sir. Now, so who can file, sir? First class, I have already told you, sir. Financial creditor, he can file for itself, that is for himself, sir. Or financial creditor can go for joint application with another financial creditor. So this part we are done, sir. Now who can also file an application, sir? Another person. On behalf of whom, sir? Financial creditor. Notified by whom, sir? Central government. Did central government notify? Answer is yes. How many people ko they have notified? 4 people ko they have notified. Now who are those? Let us take line by line, sir. Now say for example, sir, that's the reason I have taken the example of these people also, Mr. X and Mr. Y. Okay. Now say for example, Mr. X, sir, he has given loan to JP Infra. Okay, and JP Infra has defaulted this loan. Okay, so obviously Mr. Y is a financial creditor. But point is today Mr. Y cannot initiate CIRP proceedings. Reason being he is an unsound person. Okay, so he is an unsound person, sir. ऐसे सिचुएशन में लॉ मेकर्स अलाउस एक गार्डियन टू बी अपॉइंटेड फॉर whom, sir? Mr. Y, sir. So can Mr. Y file an application on behalf of Mr. Sorry, can this guardian, now imagine Mr. Guardian can be, say for example, Mr. G for guardian, sir. So can guardian on behalf of financial creditor file an application? Answer is yes. But when this is possible, sir? If he was notified. Now answer is he is notified by central government, sir. So today, can guardian on behalf of financial creditor file an application? Answer is yes, by virtue of that notice. Okay, central government has notified this person. This is point number 1. Second point, sir. Let us take example number 2, sir. Sir, imagine, sir. Now, Mr. Y ka example we have taken. Let us see one more person, Mr. X we have taken. Now, sir, Mr. X. Okay, very cash rich party, sir. Now, Mr. X is having, imagine, sir, a land and building. So he is having land and building, sir. So he is having one land and building in, say for example, Himayat Nagar area. It is one place in Hyderabad, sir. And imagine another land and building, sir. Say for example, somewhere in Gachibowli, sir. Okay, this is also in Hyderabad, sir. Okay, so he is having land and buildings, sir. Two different buildings in two different places, sir. Now, Mr. X, sir, now he has executed one will. उसने एक वसीयतनामा बनाया, वीलूनामा is what generally we say, sir. So will has been prepared, sir. In this will, what he has said, sir, he, my land and building, this imagine we are naming as A, and or we will say this Himayat Nagar property, Gachibowli property. So Himayat Nagar property will go to my son number 1, and Gachibowli wala property will go to my son number 2, sir. And all other balances, you know, whatever cash balance etc. I have, sir, iske upar jointly who will have the authority, sir? Son 1 also and son 2 also, sir. Aisa he has written this in the will, sir. So everything is written properly in the will, sir. And sir, Mr. Harish is the advocate. Mr. Harish is the advocate, sir, and he has been named as an executor in the will, sir. Now what is executor, sir? Simple logic hai. Tomorrow if Mr. X dies, whatever was the intention of Mr. X, that has to be executed, sir. That has to be done, sir. So can I say that property has to now be given to whom, sir? Son number 1. Sir, that property, that Gachibowli property has to be given to son number 2, and whatever other properties, other money balances, cash balances, etc. are there, sir, that has to be distributed to son number 1 and son number 2. So today, who has been appointed as an executor, sir? Mr. Harish has been appointed as executor. Now imagine a scenario, sir. Mr. X Mr. X has given loan to our JP, sir. Sir, JP has defaulted, sir. But imagine, sir, on behalf of Mr. X, can Harish file an application to JP, sir? Answer is yes. Why? Because Mr. Harish is an executor. Mr. Harish is an executor of estate of financial creditor. Because today financial creditor is who, sir? Mr. X. Sir, whatever this property, money, etc., इसको we call as estate. इसको we call as estate. So can I say Mr. Harish today is an executor of estate of financial creditors. Okay. So try to match these words. देखो, an executor of estate of financial creditors. So can he file an application? Answer is yes. Similarly, sir. Similarly, say for example, if at all you have remembered surfacey wala provision, sir. So can I say bank oblique financial institution, if there is a default, sir, can I say 13(2) May they were giving notice of enforcement of security interest, and 13(4) May they were having right to use ESI wala provision, sir, enforcement of security interest. Sir, usme they are having many rights, sir. One is they can transfer the assets of the company, sir. They can transfer, sale, lease, etc. Everything they can do. One more right they had was take over of management. If you remember, sir, another right they had was they can appoint an administrator. They can appoint an administrator to look after the affairs of the company. Sir, now I also told you, sir, takeover of management means what, sir? This will be a big headache for the bank, sir. So mostly, maybe they may appoint. Now imagine bank oblique financial institutions, sir. They have appoint Mr. Ahuja, who is an employee of that particular bank, sir, as an administrator. Now imagine bank oblique financial institution has enforced the what is say enforced this provision, sir. ESI provisions they have enforced, and they have appointed Mr. Ahuja as an administrator for the affairs of the company. Okay. Now, which company they are talking about, sir? Say for example, the company could be, say for example, Z Limited, sir. Okay. So Z Limited is one company, sir. So today, can I say Mr. Ahuja is appointed as an administrator for which company? Z Limited, sir. So it means what? Today, board of directors, any decision they have to take, sir, that decision will not be final unless otherwise that is approved by whom, sir? Administrator. So can I say now Mr. Ahuja will become one level ahead of one level above to board of directors. So very detailedly we have discussed this provision when I was talking about enforcement of security interest wala provision, sir. So today who has been appointed as an administrator, sir? Ahuja. Okay. Now, sir, let us take our example in this manner. So imagine today Z Limited has given loan to JP Infra. Sir, JP Infra has defaulted. JP Infra has defaulted, sir. Okay, very good, sir. So they have defaulted, sir. They did not repay the loan, sir. So now can I say Z Limited? Now we have to file an application, sir. So today Z Limited is the financial creditor. Z Limited is the financial creditor. But can I say this Z Limited के ऊपर already enforcement of security interest has happened or not, sir? So bank oblique financial institution has used their SARFAISI right, 13(4) wala rights, 13 subsection 4 wala rights, and have appointed administrator to Z Limited. So now the point is, sir, Mr. Ahuja on behalf of Z Limited, now he can file an application for initiating CIRP proceeding. So who is Mr. Ahuja, sir? He is an administrator of estate of financial creditors. Okay. Now you read those words, you will understand more properly, sir. Okay. So now you read this word, sir. An administrator of an estate of financial creditors. I hope you understood this one. Sir, 1 is over, 2 is over. Now let us take this third one point, sir. Now imagine a scenario, sir. Z लिमिटेड के ऊपर, लेट्स टेक जस्ट एक रैंडम एग्जांपल सर, जस्ट लिमिट Z लिमिटेड के ऊपर नो एनफोर्समेंट ऑफ सिक्योरिटी इंटरेस्ट हैज हैपेंड, नथिंग हैज हैपेंड. Z लिमिटेड हैज गिवन लोन Z Limited has given loan to whom, sir? What do you say? Our JP. So Z Limited has given loan to JP and that loan has been defaulted, sir. So no enforcement provision has happened. It is a normal company, sir. So now my question to you people is, Z Limited is a financial creditor. They have to file an application, to initiate CIRP with AA. Now can I say Z Limited is an artificial person. It cannot do things on its own. So what will happen, sir? Z Limited may board of directors will identify Mr. Dash, Mr. Dash, and they will authorize this person to file an application to initiate CIRP proceedings on behalf of whom, sir? Z Limited, on whom? JP. Agreed? So imagine here, sir, Mr. Rahul. So board of directors of Z Limited has authorized Mr. Rahul to file an application under section 7 for initiating CIRP application against JP, sir. So can I say, can Rahul file an application? Answer is yes. So you can see this word, sir. A person, Mr. Rahul, duly authorized by board of directors of the company. Do you think he is able to file this application? Answer is yes. So what is it I am trying to tell you, sir? Sir, I am trying to only tell you that these are also some people who are now allowed to file an application on behalf of whom, sir? Your financial creditor, sir. So financial creditor can file or these people can file, sir. So guardian can file, executor or administrator can file, sir. Person duly authorized by board of directors. So file, sir. Okay. Now, sir, remember this person is filing application. Okay, filing application to initiate CIRP proceedings. Now, who is this trustee, including debenture trustee? That already, Hannah, we have discussed this when I was discussing financial debt wala definition. So, if you remember, sir, JP Infra, sir, they have raised money by issuing debentures. So, there were many debenture holders. So, there are various debenture holders, sir. Sir, if there is a default, sir, obviously these debenture holders will be called as financial creditors. These people will be called as financial creditors. Sir, these debentures are listed, so hence we also have one debenture trustee. So debenture trustee is appointed by JP Infra only, sir. Sir, there are various duties of debenture trustee, but most important duty of debenture trustee is to protect the interest of whom, sir? All the debenture holders. He has to ensure that JP Infra timely pays the interest, timely redeems the debentures. So imagine today there is a default in interest payment or a default in redemption, sir. So can I say these are debenture holders are our financial creditors. So they have to generally file an application. But here, can debenture trustee file an application? Answer is yes, sir. So debenture trustee can also file an application. Dekho, a trustee including debenture trustee. Okay, so he can also file an application. So these are all examples of whom, sir, other persons on behalf of the financial creditors who are notified by central government can file an application. So today, if somebody asks you who are the people who can file an application, my answer will be financial creditor. My answer will be other person. Financial creditor either by himself or jointly with other financial creditor. Other persons may which persons, sir? Only those people who are notified by C, sir, and they are filing not for themselves, sir, but on the behalf of financial creditors. And who are those notified people, sir? These are those four notified people. So this is one small point which you have to understand. Okay, next. Sir, what is the condition for filing an application, sir? Most important thing is default. Default by whom, sir? Corporate debtor. Of what? Financial debt. Sir, this default should be the one, should be to whom, sir? The financial creditor who is filing up, or it can be to any other financial creditor also. It can be to any other financial creditor also. So default can be owed to the applicant. It means what, sir? If SBI is filing an application, it can file an application for its default also. ICICI, for them, no default has happened, but still they have filed an application because default has happened for SBI. And SBI was not willing to make an application. So can I say default can be to the applicant, default can be owned to any other financial creditor. Okay, this point you have to understand. Now, sir, when you are filing an application, do you think some documents etc. you have to attach? Answer is yes. So you have to give certain documents oblique information along with the application, sir. Okay, what are those? One is record of default. From where you can get this? I already told you, sir. Information utility. Section number 215 May, it was mandated for whom, sir? Every financial creditor to file an application. Sorry, yes, section number 215 में it was mandated for every financial creditor, sir. What? Whenever he is giving any financial debt to whom, sir, other party, sir, they have to ensure that that transaction is getting recorded with information utility. Agreed or not, sir? Yes. Sir, similarly default हुआ at that time also they will make an application or they will record this transaction with information. Sir, uska copy you have to give along with the application because this will act as a proof that there is a default, sir. I hope you understood this point, sir. Sir, but I also told you, if you remember, today an information utility has been notified or information utility has been established only for financial creditors regulated by RBI. So here in our example, Mr. X has also given loan, Mr. Y has also given loan, SBI has also given loan, ICICI has also given loans. Agreed? So ICICI, when they give the loan, sir, obviously at the time of giving loan they might have recorded this fact in the IU, sir. So can I say it will be very easy for them to take the copy from IU because today National E-Governance Services Limited has been established as an information utility for financial creditors governed or regulated by whom, sir? RBI. But what about Mr. X? Imagine a scenario, application is not filed by SBI, application is not filed by ICICI, but application is filed by Mr. X or Mr. Y. Sir, they are financial creditors but not regulated by RBI, sir. Obviously, they cannot file this application with National E-Governance. And if this is not the IU, sir, no other IU is yet established, sir. So presently, we have only one IU, sir. So ऐसे situation में lawmakers have used a word. What is the word used, sir? If at all you cannot bring record from IU, if at all you cannot bring record from IU, record of default from IU, or you bring or you try to show some other evidence that there has been default, sir. Now what would be that other evidence? Maybe you can submit your bank statement. So you can show the proof that देखो this is our bank statement, there is no entry with respect to interest payment, there is no entry with respect to repayment of loans, है ना? So total bank statement you try to satisfy this and give this as an attachment, sir, so that AA will get satisfied. Okay, this is one point, sir. Second, I also told you, sir, it is compulsory for financial creditor to propose one particular person's name as what, sir? IRP, interim resolution professional, sir. Sir, from where you will get this person's name, sir? I already told you, IBBI website mein you will be having more than about 3,000 people insolvency professional are registered and their names are being registered with IBBI, sir. So from there you can select any one person and you can write that person. Obviously when you select somebody you have to intimate that person also, sir. Okay, so that is one point, sir. Next, and third, you have to give such other information as specified in regulation. And who will prepare this regulation, sir? Court, sir. Remember, whenever the word used in law is prescribed, in this law I'm talking about, sir, that will be specified or that will be given in rules. But whenever the word used is specified, that will be provided in your regulation. Sir, rules are prepared by central government and regulations are prepared by IB. Okay, so these are the points, sir. So here, what is the word I'm using, sir? Sir, financial creditor is filing an application. Is filing an application with whom, sir? AA. Why, sir? To initiate CIRP against the corporate debtors. While filing application, we have to give three things, sir. What are those, sir? One is, sir, record from IU showing that there is a default or some other evidence showing that there is a default, sir. Second, we have to give the name of our proposed IRP, sir. Third, all other documents which are specified in IBBI regulation. Now, regulations are not forming part of our syllabus, sir. So, all these three details, financial creditor, you try to provide this to whom, sir? Adjudicating authority. So that adjudicating authority will ascertain whether default has happened or not. If has happened, then they will admit the application or they will reject the application. That is different part of the story, sir. Till now, we are only with respect to financial creditors wala point, sir. Then we have seen financial creditor, you can file for yourself also. Matlab financial creditor itself can file or joint application can file. For their default they can file or for some other financial creditor ka default they can file. So now can I say application is filed. Now let us discuss total point of view from AA, sir. Now what will happen, sir? Can I say JSA application is filed with adjudicating authority. Now it is a duty of adjudicating authority to ascertain to ascertain. What they have to ascertain, sir? Whether default has happened or not, sir. Okay, sir, for ascertaining and passing order, there is a time limit given. What is the time limit, sir? Within 14 days they have to either admit the application or they have to reject the application. So either you say yes or you say no, sir, है ना, within 14 days, sir. So देखो, here this is what it is written: AA shall ascertain existence of default and then pass its order. So only ascertainment of default is not enough. You have to ascertain the default also, pass the order also, for which you are getting 14 days. 14 days from when? Independence Day of India? No, 14 days from the date of receipt of application. So say application you receive, within 14 days you have to ascertain the default, pass the order, sir, whether default has happened or not, sir. Now, sir, when you pass an order, sir, can I say you have to look into some matters, sir. First is you should be satisfied. What you should be satisfied? The default has occurred. Next, you should ensure that application is complete. Now, what do you mean by application is complete? All those attachments which are required to be given are given. All those information which is specified by regulation is properly made. So, complete, full-fledged application. Sarvaguna Sampan, that application. And third, can I say the name you have proposed on this person, no disciplinary proceedings should be pending, sir, because we don't want a person who is in this, sir. Imagine on this person, now say for example Mr. Ramu is proposed as IRP, sir. On him already some disciplinary proceedings are going on, sir. Sir, ऐसे व्यक्ति को है ना, we don't want to be appointed as IRP, sir. So we will ensure that name of this, for the whoever the name you are proposing, sir, on him no disciplinary action should be pending, sir. Okay, so these three things who will ensure, sir? AA will ensure. So what are the three things AA should ensure, sir? First, they have to check whether default has happened or not. Second, they have to check whether application is complete or not. And third, they have to check no disciplinary actions are pending, sir. If these three things they are satisfied, sir, then they will admit the application. And the date on which they admit the application, CIRP proceedings will start. This is the date of commencement of corporate insolvency resolution process. Now, this is what I have already told you, sir. Okay. Now, sir, now the question is this. Sir, 14 days may you will admit the application. When you will admit the application, I said you have to ensure that these 3 points are satisfied. All 3 are any one now. Obviously, all 3. Obviously, all 3. So, can I call this? These are 3 conditions for admission of application. What are the 3 conditions, sir? Application complete रहना, sir, default होना, and disciplinary grounds नहीं होना, sir. If these 3 things are satisfied, these 3 things are proved, then within 14 days I will pass an order for admitting the application. But imagine a scenario, sir, these 3 may, even if one thing is not satisfied, what should I do, sir? Reject the application, sir. So say for example default has happened, obviously I will reject the application, or application is incomplete, I will reject the application, or disciplinary grounds are pending, I may reject the application. So can I say for rejecting 3 conditions, or any point you satisfy, that is more than enough? Any point you satisfy, that is more than enough. But for admission of application, all 3 conditions you have to fulfill. So this is what I have written. Dekho, author's note. For admitting application, 3 conditions are to be fulfilled. But for rejecting, any point is to be fulfilled. This is what case 2 is. Case 2 ko you have to write in a reverse manner. What if AA is satisfied that default has not occurred? So if default is not occurred, why should we initiate CIRP proceedings, sir? Company is not off the track, then why should we initiate CIRP proceedings? Or application is incomplete, sir. Can I say application default has happened, but can I say application to incomplete hai na bhai, hai na? So we will reject, sir. Or disciplinary proceedings are pending, sir. Also. But don't you think before rejecting it, sir, we should give time limit for correction or not, sir? Yes. Hence what they are saying, sir, okay, if any of these 3 things are happening, sir, you please directly reject mat karna, you please give time limit for rectifying, sir. How much time limit should I give, sir? 7 days time limit you give, sir. Sir, 7 days may also, if they don't rectify the default, sir, at that time you can reject the application. I hope you understood this point, sir. Okay. Now, sir, अब एक छोटा सा point I would like to tell you, sir. What is that, sir? Sir, financial creditor has filed an application with AA within 14 days. Within 14 days, I have to ascertain. What I have to do, sir? Ascertain default and pass the order, sir. When I will pass the order, sir, if 3 conditions are fulfilled, sir. Okay, if any one point is not fulfilled, sir, sir, I am not directly rejecting it. First I will give 7 days a time to correct it, and if it is not corrected then I will reject the application, है ना. Similarly, है ना, whenever somebody is doing wrong, sir, why we are giving this 7 days ka time limit, sir, so that you can correct your application. Imagine disciplinary grounds are pending on that particular person's name, so you may change that person's name and you may what is say propose the name of new IRP, sir. So Ramu के ऊपर disciplinary proceedings है तो शाम को लगा दो सर, है ना. So that point is always possible. So you may do corrections, and then with 7 days में also if you don't do corrections, sir, obviously your application is going to be rejected. Now, sir, अब एक विचित्र thing क्या था sir? Sir, application was admitted. 14 days are over. 14 days are over. What you were supposed to do? Ascertain default and file the order, sir. Sorry, ascertain default and pass the order. Now imagine a scenario. Most of the time, practical grounds में what we have observed was 14 days हो गया. Neither I have admitted the application nor I have rejected the application. ये भी नहीं किया, वो भी नहीं किया. ఇది కూడా చేయలేదు, అది కూడా చేయలేదు. Sir, neither I have admitted application nor I have rejected application. तो इसका मतलब maybe there could be some reason na कि why you could not do that, sir. So if imagine a scenario, 14 days are over, you are still, है ना, you did not pass the order, did not ascertain the default, sir. If there is a delay, if there is a delay, now there is a small amendment. What they are saying, sir, whenever 14 days में either admission or rejection does not happen, sir, okay, no problem, you are passing an order, no problem, but ensure that reasons are given. What are given, sir? Reasons are given. Correct hai na bhai? Sir, you did not pass order, you did not reject order, there could be some reasons, no? That reasons you please ensure that you write down in your order. That reasons has to be recorded, hai na? So indirectly can I say like this? Indirectly can I say like this? We are putting one pressure on whom, sir? Adjudicating authority, sir. Why? If he does not passes the if he does not passes the order by adjudicating the default within 14 days, now he has to give the reason, sir. So can I say this will create an indirect pressure on him, sir? Why? If I delay, I have to tell the reason, and that reason should be genuine reason also. Maybe due to pandemic situation, I could not give the order within 14 days. Maybe we could not ascertain the default, sir. This was a very complex case and we could not ascertain default. So you should give proper genuine reasons. Then you may admit the application or reject the application even after 14 days. Now this is inserted via amendment in 2019 wala act, sir. So dekho, so important hai, this is an important amendment which has happened, sir. Let us see. If the adjudicating authority has not ascertained and passed the order, sir, it shall record its reasons. It shall record its reasons. So you have to give your reasons in writing, sir. So either you should admit or you should reject. For this, how many days are there, sir? 14 days are there. 14 days are over. Neither this has happened nor that has happened. No problem, sir. Sir, subsequently, whatever order you pass, sir, ensure that you give the reasons. That is what this is saying. But remember, sir, this type of points are not added. Now, this is inserted via amendment, but these type of points are not added for what, sir? Section 9 wala application, section 10 wala application. What would be the consequence of that? That I will discuss when I explain you section 9 and 10, sir. So this type of amendment, this insertion has happened only for section 7 wala application, but not 9 and 10 wala application. What is 9? I already told you, sir. Operation creditor is filing an application. 10 May corporate debtor itself is filing an application. Now tell me, sir. Sir, whatever order AA passes, can I say they have to communicate the order or not, sir? Now, the point is, if they admit the application, obviously they will communicate the order to financial creditor. But can I say they have to also intimate the corporate debtor, saying what? Anna, your CIRP proceedings has been initiated. But if they reject the application, sir, so can I say now they have to give this order only to financial creditors, not to whom, sir? Corporate data, that is JP Infraco need not be given, sir. Why? Can I say nothing has happened for JP Infra? Why should we do unnecessary gulgul to them, sir? So hence this copy of order is to be given only to financial. Okay, so this is one small point you have to understand. And within how many days? The adjudicating authority shall within 7 days of its decision communicate the order to whom, sir? This is how it is, sir. I hope up to here things are clear, sir. So what are the points we have understood, sir? Simple hai. Who can file an application? So I told you, for a creditor other than home buyer, other than debenture holder, उसका ऊपर small amendment is उनको छोड़ दो sir. For all other creditors, a financial creditor itself can file an application or jointly they can file an application, or any other person है ना on behalf of financial creditor notified by central government. How many people are notified sir? 4 people are notified. Sir, these people can file an application for their own default or for the default of another financial creditors. Okay, this point is done. Now, once you file an application, can I say you have to give three things, sir? One, you have to give the evidence of default. So you take the copy from IU, which shows evidence of default, sir. Either that you prove or such other evidence of default, sir. So these words are very important now. Such other evidence of default, sir, because sir every financial creditor के लिए IU is not yet established, so you have to give such other evidences for a default, sir. Then name of proposed IRP, sir, and third, information specified by what you say IBBI in their regulations. All these things you give to whom, sir? AA. Now AA within 14 days either has to admit or reject. If they have to admit, three conditions they have to fulfill. What is that, sir? Application should be complete, sir. IRP के ऊपर no disciplinary proceedings has to be done, and there is a default, sir. Then you admit the application. Otherwise, you reject. If both things you don't do, whatever order you subsequently pass, sir, ensure that reasons of the same is given, sir. We want your order to be a speaking order, sir. Other party should understand why the delay has happened, sir. Okay, and whenever you pass any order within 7 days, ensure that you deliver the copy of order. Now, if you admit the application, to both the people, if you reject, only to the person who has made the application. That is nothing but credit answer. I hope you understood this one. अब amendment किसमें है sir? Now amendment is with respect to this part, sir. So whatever we have discussed है ना, एक छोटा सा chart I have already prepared, sir. So can I say financial creditors को I say point A financial creditor, point B वाला financial creditor, other financial creditor. What is other financial creditor? All financial creditors other than home buyers, other than security holders, है ना. So these people, this thing I have already discussed. Now home buyers के ऊपर, security holders के ऊपर there is a small amendment, sir. Now what is that? Let us understand, sir. Now what they are saying, sir, if at all real estate allottees or security holders, you can understand, sir, company has raised money by issuing, sir, note purchase facility wala scheme, bonds, commercial papers, etc., sir. ऐसे situation में default happen, so those people are security holders, sir. So obviously what is a common thing between them, sir? Home buyers, they will be large in numbers, sir. Similarly security holders, they will be large in numbers. So debenture holders, etc., they will be large in numbers. So what lawmakers are saying, sir, individual applications we will not entertain. So there is an amendment 2020 wala amendment mein, sir. So IBC Amendment Act 2020 में they said what? Individual applications no more will be entertained. Joint application should. Now joint application का what is the criteria, sir? Lower of कितना? 100 or more of such creditors. Now what do you mean by such creditors? If it is home buyers, then all home buyers ka 100 or more, or 10% or more of total number of such creditors. Let us understand, sir. Imagine total debenture holders are in the company, say for example 100, say for example 500 debenture holders are there, sir. So ऐसे situation में what we want is what, sir? At least 100 debenture holders, or 10% of 500, it will be how much, sir? 50, sir. Whichever is lower here is what, sir? 50. At least 50 people jointly has to make an application. So this is what a new amendment which you have to understand. So can I say same thing goes with home buyers also, sir? So imagine JP Infra is having one project which is going on in a particular area, sir. That project may, imagine instead of debenture holders 500 allottees are there, sir. Okay, so how many people, sir? Again 100 or more of such creditors. So can I say this project is going on in one particular area, so that particular area के लिए how many allottees are there? 500, sir. So at least 100 or more, or 50, whichever is lower, 50 allottees joint application they have to make, sir. Okay, now sir, now you may be saying, sir इससे what will happen, sir? इससे can I say earlier if there is a default to one allottee also, sir, he could have filed an application. But now what is happening, sir? Individual application we are not allowing. We are only entertaining what, sir? Joint applications. इससे can I say number of applications with NCLT will increase or decrease? Obviously it will decrease, sir. Why it will decrease, sir? Because we are now putting one qualifying limit. We are now putting one qualifying limit for whom, sir? These special type of financial creditors. Who are this special type of financial creditors, sir? Home buyers or security holders. These people are there in 21(6)(a), sir. So section 21 subsection 6(a), when we discuss, and उसमें भी you have clause A clause B है ना, there we will be discussing them. Okay, so these are those people, sir. उनके लिए एक special limit has been given, sir. So if these many people are there, then only they can file an application. Otherwise, they cannot file an application. In all the cases, I told you default कितना होना चाहिए, sir? 24th March को है ना, notification has come, and that default amount should be what, sir? Minimum 1 crore. Earlier it was 1 lakh, but now government has notified that default amount should be minimum 1 crore. So now IBC में limit is what, sir? Minimum 1 crore, and this is applicable for your November exam also and future exam. Okay, so this point I hope you understood. Now, sir, now the question is, what could be the logic of bringing this amendment, sir? Okay, very important amendment, sir. IBC amendment 2020 ka very important, applicable for your November exam. So what could be the logic, sir? So I tried to find out, sir, as on September 2029, okay, as on September 2029, what we observed was 10,860 cases were pending with NCLT. उसमें स्पेशली 1821 cases were only of home buyers, meaning 17% of total applications. इतने सारे applications were pending, sir. So can I say more or less what was happening, sir? Too many applications of only home buyers were coming, sir. Hence we thought what, we want to reduce this application. Hence we brought the qualifying limits. So you may be saying what, sir, ये तो गलत हो गया, this is wrong, this should not happen, sir. In fact, law should motivate the creditors to receive the money. What is this? This is demotivating them. This is ensuring that these people do not receive their money. That is not the logic, sir. Can I say all these allottees, etc., they have a remedy as per real estate regulatory and development real estate regulatory and development authority act also, sir. So as per RERA also they are having the remedy, sir. Sir, as per consumer protection act also they are having the remedy, sir. So yes, they are not having now, matlab maybe, sir, thoda demotivating amendment it is for them, sir, in IBC. But can I say they can claim the remedy in RERA, they can claim the remedy in what, sir? Consumer protection act. That is always available to them. So this could be the reason, sir. You may say for security holder, debenture holders, can I say there they can file an application with NCLT, sir. If at all redemption does not happen in time limit, sir, if at all interest is not paid, sir, NCLT NCLT is always there to entertain their application. So they can use specific sections of Companies Act. They can, home buyers can use RERA ka provisions or Consumer Act Protection Act ka provisions. So that is the logic why we thought what, even already alternate remedies are available, sir, here thoda tightness we will bring, sir, by introducing this qualifying. I hope you understood. Okay, now सर नेक्स्ट क्वेश्चन ये है, सर ये जो अमेंडमेंट है, हाउ इट हैज कम, सर? इट इज इंसर्टेड वाया इंसॉल्वेंसी बैंक्रप्सी कोड अमेंडमेंट एक्ट 2020 which is effective from 28/12/2019. Okay, now tell me, sir, एक छोटा सा क्वेश्चन आई वुड लाइक टू आस्क यू, सर. Now can I say I can divide the time limits like this. 28/12/2019 को what has happened, sir? Insolvency Bankruptcy Code Amendment Act 2020 has come. Sir, 19 में effective है, retrospective amendment, sir. Sir, इससे पहले we used to have Ordinance Act. So that Ordinance Act को effectiveness we wanted to give. So that is the reason backdatedness के साथ this IBC code has been implemented. Now, sir, from this day onwards, sir, we are saying that criteria we are putting for home buyers and deposit holders. Sir, previously, now can I say there could be some applications, which are pending. There could be some applications which are pending. Imagine till 27/12/2019 ko there could be some applications which are pending with whom, sir? NCLT, of whom either deposit holders or home buyers. Obviously they might have not given joint applications, some might have given, but mostly the joint applications might have not been given, individual applications might have been given, sir. So what would be the fate of those applications which are already filed but pending, sir? And see, for already if it is accepted, nothing we can do, but if they are pending, what will happen to them? Sir, now lawmakers said, sir, as on 28/12/2019, if these applications which are already filed and they are pending, we will be giving 30 days a time limit. We will be giving 30 days time limit to modify your application, to ensure that now these applications are in compliance with the Amendment Act 2020. 30 days का time limit we are giving, sir. अगर this is not done within 30 days, it will be deemed withdrawal. It means what? Your application was never, you have never filed an application, or you have filed an application but now you have withdrawn your application. So this is also one point which is written, sir. Okay, so what we will do, sir, now we will be discussing only this specific amendment part. Let's see. In case of financial creditor covered under section 21 subsection 6a clause a clause b, sir. Okay, so security holders, depositors, we are talking about, home buyers we are talking about. So what we are saying, sir, joint application, है ना, joint application by whom, sir? 100 or more of such creditors, or 10% or more of total number of such creditors. Sir, if home buyers है तो you may put here home buyers, home buyers. Home buyers नहीं है तो you can put what, sir? Deposit holders, creditors, etc. Whichever is lower, sir. Okay, so same logic here also, sir, same number it is, but this is exclusively covering only for home buyers. So I told you here itself, sir. Next, note, in case an application which is filed by security holders or home buyers and has not been admitted by adjudicating authority before the commencement of this law, such application has to be modified within 30 days from the commencement of this act. What is that, sir? 28/12/2019. Failing which, the application is deemed to be withdrawn before its execution. Okay, so I hope you understood this point, sir. Okay, so this is our small section, which is section number 7, for filing an application for initiating CIFP proceedings by financial. Okay, thank you very much.